Are there differences in cybersecurity laws by state? Have you ever wondered how cybersecurity laws can change from one state to another? It's a fascinating topic that impacts businesses and individuals alike. Yes, there are notable differences in cybersecurity laws across the United States. While federal laws set a basic framework for cybersecurity and data protection, each state has its own unique statutes that can vary widely in terms of scope, definitions, enforcement, and penalties. At the most basic level, all states have data breach notification laws. These laws requiring organizations to inform affected individuals and authorities when personal data is compromised. However, beyond this common requirement, state laws diverge significantly. For instance, California has some of the strictest cybersecurity and privacy laws in the nation. The California Consumer Privacy Act grants residents extensive rights over their personal data. This includes the right to know what data is collected, the ability to request deletion, and the option to opt out of data sales. This law applies to large businesses that meet specific thresholds and imposes hefty fines for noncompliance. California also has strong cybercrime laws that address issues like hacking and identity theft, with severe penalties for violations. New York has its own set of regulations known as the SHIELD Act. This act enhances data breach notification, requirements, and mandates that businesses implement various safeguards to protect personal information. This includes biometric data and login credentials. The focus here is on protecting financial data and consumer privacy, with enforcement led by the state attorney general. Other states, such as Massachusetts and Illinois, also have robust data protection laws. These often requiring specific security measures and impose penalties for violations. On the flip side, some states have more lenient regulations, creating a patchwork of laws that businesses must navigate if they operate in multiple states. In addition to privacy and data breach laws, state cybercrime laws differ in how they define offenses and penalties. For example, Texas places a strong emphasis on protecting personal data and penalizes businesses for inadequate security measures. Meanwhile, New York focuses on cybercrimes related to financial information. From the perspective of law school, understanding these differences is essential for students specializing in cybersecurity law. The variability in laws means that students must be well-versed in both federal frameworks and state-specific regulations. This knowledge is vital for advising clients effectively and ensuring compliance with the law. In practical terms, cybersecurity law specialists must analyze diverse statutes and understand how state laws interact with federal requirements. They also need to anticipate legal risks based on jurisdiction. The ongoing discussions about the need for a uniform federal data privacy law highlight the complexities of compliance and enforcement. In summary, cybersecurity laws vary widely by state, covering differences in consumer privacy rights, data breach obligations, security requirements, and definitions of cybercrimes. This diversity shapes the practice and study of cybersecurity law, making state-specific knowledge essential for legal professionals in this field.